Well, the trial continues for a second day today for two former child welfare workers who managed the case of a 5-year-old boy who was killed by his parents.
Dana Rebick is live in the newsroom with the latest on this. Dana?
Well, things in court really didn't get underway until after lunch today due to some confusion this morning over DCFS policies and procedures, documents that were submitted into evidence yesterday and which were in effect before and after AJ Friend's death. That all got sorted out, and then the DCFS expert witness we saw last up on the stand yesterday returned for further testimony. Now, this is when we got a more in-depth look at Joanne Cunningham's history with DCFS, police, and her problems with substance abuse. In October 2013, when AJ was born, he tested positive for opioids and was removed from her custody and placed in foster care with a relative. In March 2018, Cunningham went to Gottlieb Memorial Hospital after being found asleep in her car with track marks on her arm, feet, and neck, where she denied drug use but then admitted to relapsing. In June 2018, Cunningham was discharged from Sundance Methadone Clinic for ongoing drug use and not showing up there. A month later, she wound up at Mount Sinai Hospital in the psych ward after a battery arrest involving her boyfriend, reports of suicidal behavior, and admitting to using heroin for the past 6 years. Now, in court today, McHenry County State's Attorney Patrick Keneally walked through that timeline with Carol Ruzicka, a retired DCFS supervisor. Ruzicka says that Carlos Acosta and his supervisor, Andrew Polovin, failed to review Cunningham's past history with DCFS, her criminal background, and history of substance abuse and mental health issues, nor did they screen the boy's father, Andrew Friend, or Cunningham's boyfriend at the time, Daniel Nowicki. In addition, the state says Acosta failed to discover an order of protection Cunningham's mother filed against her and two prior unfounded DCFS abuse and neglect cases involving her older son and a foster child that was removed from her care previously due to allegations of drug use and poor conditions in her home. Now, in December 2018, when Crystal Lake police took AJ and his brother Parker into protective custody, Acosta had 48 hours to gather that evidence and determine if it was safe for those boys to return home. But he let protective custody lapse, saying as long as Joanne Cunningham took AJ to a doctor to have that bruise evaluated, AJ said that it had come from his dog's paw.
Did defendant Acosta ever ask AJ to demonstrate how the dog caused the injury?
No.
Did he appear to ask him how hard the dog had hit him?
Nope.
Should he have?
Yep. Yes.
Did it appear as though defendant Acosta explored other possible explanations for the injury with AJ?
No.
Should he have?
Yes.
And we now know that AJ told an ER doctor that the bruise came from a belt, and he told that doctor, quote, "Maybe mommy didn't mean to hurt me." Acosta was also required to attend that exam at the hospital, but did not. He also did not request a second opinion, which is mandatory under DCF policy when there are conflicting stories about an injury. We'll have more on today's court proceedings coming up at 6 o'clock. Live in the newsroom, Dana Rebick, WGN News.